The first time I met Sheila Warden, she was standing in my driveway with a clipboard and a glare that could peel paint. "You can't leave your trash bins out past 8 a.m., she barked. "It's in the HOA bylaws." Page 12, Section 3. I was still holding my coffee, wearing pajamas, and hadn't even finished moving into my new house yet. "My name's Fletcher Sanders," I said, trying to sound polite. "I just closed 2 days ago, haven't even unpacked my socks." "I'll read the bylaws when I find the box they're in." She didn't laugh. Sheila was your textbook HOA Karen mid-50s, over bleached hair, sunglasses bigger than her forehead, and a permanent scowl like someone duct-taped a lemon to her face. She was the HOA president, self-appointed enforcer and part-time menace. I'd bought the house as a foreclosure. It came with an overgrown yard and a little side parcel of land that, according to the county records, was legally attached to the property. That side lot was what started the war. 2 weeks later, I was clearing debris from it when Sheila stormed over with a manila folder and a smug look. "You can't touch that land," she said. "That's HOA common space." I straightened up. "No, it's not. I checked the deed." "It's mine." She clicked her tongue and held up the folder like it was gospel. "I have maps, Mr. Sanders. That land belongs to the HOA. We've maintained it for years. You'll be fined if you keep trespassing." I didn't argue. I just nodded and walked back inside. My background in property law had taught me one thing: never argue with someone who thinks yelling makes them right. Let the documents do the talking. A week later, I got a certified letter. Sheila and the HOA were suing me for encroaching on HOA-maintained property, demanding I cede the side lot and pay for damages and legal fees. They claimed the land was part of a greenbelt and that I was destroying community aesthetics. I laughed when I read it, then got to work. I pulled the chain of title from the county recorder's office, the foreclosure paperwork, the original survey from the subdivision's creation in the 90s, and the kicker, a warranty deed from the year Sheila bought her house, which showed something very interesting. She didn't actually own the full lot she thought she did. Sheila's deed was misfiled. Her property line ended 4 feet sooner than the fence around her backyard suggested, and those extra 4 feet, legally, they were mine. I triple-checked everything, had a surveyor confirm it, and then filed a quiet title action not just to defend my side lot, but to formally claim the sliver of land Sheila had been using as her own backyard for 20 years. I didn't say a word to her. But she sure had plenty to say when she found out. Sheila found out about the quiet title action on a Thursday morning, when a process server handed her the court notice while she was pruning the azaleas in front of her porch. I watched from my living room window as she stared at the envelope like it had teeth. She opened it right there in her driveway. First came confusion, then her jaw clenched. Then she marched straight to my front door and rang the bell like she was trying to set it on fire. "You think you're clever?" she snapped the moment I opened it. "This is harassment." I didn't invite her in. "You're welcome to file a response with the court. You filed a claim on my backyard, No, I filed a claim on a strip of land that's recorded in my deed and isn't in yours. You've been using it without legal right." She held the envelope like it might burst into flames. "That's been ours for years. I've got a shed sitting back there." "Then I suggest you move it." She didn't say anything for a few seconds, just stared at me like I was a smudge on her windshield. Then she spun around and stormed off, the envelope crumpled in her hand. I figured she'd lawyer up. What I didn't expect was what came next. The following day, 2 uniformed officers knocked on my door. One of them, a younger guy with a clipboard, asked if I was Fletcher Sanders. When I said yes, he informed me that I was under investigation for unauthorized excavation and destruction of protected HOA property, and that I needed to accompany them to the station for questioning. Sheila had filed a police report. At the station, the detective asked me about my landscaping work, specifically the clearing I'd done on the disputed lot. I told him I'd removed dead brush and cleaned up the area. Nothing more. He flipped through photos. Someone had taken close-ups of tree stumps and piles of dirt. According to the complaint, he said, this area was designated as a conservation buffer. I raised an eyebrow. By who? He shrugged. HOA claims it was agreed upon in a 2004 amendment. I asked for a copy of that amendment. There wasn't one. There was only a typed statement from the HOA board, signed by Sheila and 2 other members, claiming the land had always been maintained as a protected zone. I handed over the property records I'd brought with me: survey maps, deed history, zoning documents from the city, and the title report confirming ownership. The detective skimmed through them, then let out a long breath. Well, he said, this complicates things. It did more than complicate things. It exposed them. That weekend, I dug deeper. I requested public records from the county planning department. Turns out the HOA had never filed any conservation documents for that lot. There were no easements, no restrictions, no zoning overlays. In fact, 2 years earlier, the HOA had tried to rezone that exact parcel to sell it to a landscaping company until the sale fell through when the buyer discovered Sheila couldn't prove ownership. That's when I realized this wasn't just a petty turf war. Sheila had known the land wasn't hers. She'd known, and she'd still tried to sue me off it. Worse, she'd lied to law enforcement in an official complaint. I gave everything to my attorney. The court date for the quiet title action arrived 2 weeks later. Sheila showed up with a lawyer in tow and a thick binder labeled HOA property documentation. Her attorney tried to argue that historical use gave the HOA claim to the side lot. Mine responded by handing the judge the warranty deeds, survey plats, and a signed affidavit from the original subdivision developer confirming the parcel was intended as part of Lot 17, my lot. The judge didn't take long. He ruled in my favor and signed the order clearing the title. But I wasn't done. 3 days after the ruling, I filed a formal complaint with the county district attorney's office, accusing the HOA board of filing a false police report and attempting to defraud me of legally owned property. I included statements, maps, and the failed rezoning attempt as evidence of deliberate misrepresentation. Then things got ugly. The county investigator assigned to the case interviewed city planners, reviewed old HOA meeting minutes, and confirmed a pattern of fabricated documentation. Turns out, Sheila and her board had created several internal amendments over the years, none of which were filed with the county, city, or even properly voted on by residents. These documents were used to justify fines, threaten homeowners, and block property improvements. The most damning piece. A memo dated 3 years prior where Sheila instructed the board's secretary to retroactively designate buffer zones after a homeowner built a patio she didn't like. The DA's office opened a formal investigation into HOA fraud, misuse of authority, and falsification of documents. The news spread fast. At the next HOA meeting held in the clubhouse that smelled like stale coffee and old carpet, I attended with a folder full of copies for anyone who wanted to read them. I didn't say much. I just placed the stack on the back table and took a seat in the 3rd row. The room was packed. Neighbors I hadn't even met whispered as they flipped through the pages. Sheila sat at the head of the table, pale and silent. When someone asked if she'd really tried to sell common land without a vote, she didn't answer. Another neighbor stood up. Is it true you filed a police report based on made-up documents? She opened her mouth, but the HOA treasurer cut in. I didn't sign off on any of that, he said. I want it on the record. Sheila stood. We're not legally required to file every internal amendment with the county. This is a coordinated attack meant to destabilize. Someone laughed, loudly. Then more joined in. Sheila's voice rose. You think this is funny? He's trying to take my land. I stood up calmly. No, I'm reclaiming mine. That's when the treasurer did something unexpected. He motioned to the rest of the board. We're calling an emergency vote to suspend board leadership pending legal review. All in favor? Hands shot up. More than half the room. Sheila tried to protest, but the secretary read from the bylaws yes. the real ones that allowed members to vote on leadership changes if legal violations were suspected, Sheila left the meeting in silence. The next week, she resigned. I kept the side lot. She had to tear down her shed. And the sliver of land behind her fence. I fenced it off and turned it into a tiny community garden open to anyone on the block. Someone planted tomatoes. Another neighbor brought herbs. I installed a little bench and a sign that read, "Welcome to Lot 17.5. The new interim HOA board, led by a retired postal worker named Glenn, opened an audit into all past fines and amendments. Several homeowners had their records wiped clean. A local reporter picked up the story and ran a feature on the man who beat the HOA with their own paper trail. Sheila's house went up for sale a month later. A "for sale by owner" sign leaned crookedly in her yard. No one shed a tear. 3 weeks after Sheila resigned, the interim HOA board held a special session at the city library's community room. The agenda was simple: open the books, review every decision made during Sheila's tenure, and determine the extent of the legal fallout. Glenn, the retired postal worker now serving as interim president, had already uncovered several discrepancies: unauthorized expenditures, missing meeting minutes, and checks written to a landscaping company that didn't exist on any state registry. I wasn't on the board, but Glenn had asked me to attend as an unofficial advisor. I agreed, mostly to make sure nothing slipped through the cracks, especially since I'd discovered something troubling in the course of researching my case. Turns out, the land dispute wasn't the only irregularity on paper. While combing through the county's plat filings, I'd found a second misfiled deed, this one attached to the property adjacent to mine, where Sheila's friend and former board secretary, Dolores, lived. The legal description on Dolores's lot overlapped slightly with Sheila's. Small, just under 100 square feet, but enough to raise questions. When I cross-referenced it with satellite images, it became clear. Sheila had built her back fence several feet beyond her actual lot line. And not just onto my parcel. She'd taken a piece of Dolores's yard too. I brought it to Glenn's attention the night before the meeting. She altered the fence line. Glenn frowned and leaned over the maps. That's not a mistake. You don't accidentally put a fence through someone else's lawn. That's what I thought, I said. But there's more. Look at the contractor permit for the fence installation. It's signed off by an HOA inspector. Let me guess, Sheila herself? No, her husband. He was listed as the HOA's property compliance officer. He signed off on the permit 5 years ago. Glenn let out a long breath. We need to bring this to the city. If she used a false permit to claim land, that's fraud. The next morning, I filed a formal report with the city zoning department. They launched an immediate investigation into the fence permit and the misappropriated land. Dolores, who'd been supportive of Sheila for years, was blindsided. She confronted Glenn privately, then asked to speak at the board session. When Dolores stood before the room, she looked like someone who'd just been told her house had been built on quicksand. Her voice trembled not from nerves but fury. She lied to me, she said. She had me sign a landscaping agreement for what I thought was a shared boundary. Turns out I was signing away part of my own yard. A murmur rippled through the room. Glenn raised his hand for quiet. I've already spoken to the city inspector, he said. They're sending out a survey team to confirm the property lines. If it's proven she falsified permits or used her position to mislead residents, this could escalate into criminal charges. And it did. 2 weeks later, the city investigator returned with a full report. Sheila had filed fraudulent improvement permits under the HOA's name, bypassing required resident votes. She'd approved fence extensions, patio expansions, and even a retaining wall, all without proper authorization. Worse, several of the invoices for these projects had been paid out of HOA dues. That's when the police got involved. Detective Ramirez from the county's financial crimes unit requested an interview. I handed over everything: maps, permit records, bank statements from the HOA's public filings, and several emails I'd recovered from an old Yahoo group used by the board. One of them was from Sheila to her husband. "We'll get the fence signed off and deal with Fletcher later. He hasn't moved in yet. By the time he figures it out, it'll be too late." That email became the cornerstone of the criminal case. Sheila and her husband were arrested on charges of fraud, misuse of HOA funds, falsifying government records, and conspiracy to unlawfully seize property. Dolores filed a civil suit against them the same week, seeking damages for the lost use of her land. The neighborhood, once polite and quiet, erupted in a flurry of activity. Homeowners who'd been fined for supposed violations began demanding refunds. Others started digging through their own records, finding discrepancies in their lot lines, permit approvals, and HOA dues. One family discovered they'd been paying an extra annual green maintenance fee that wasn't listed anywhere in the bylaws. A special audit committee formed under Glenn's supervision. I volunteered to assist, along with a retired CPA named Marjorie who used to work for the IRS. She brought a level of scrutiny that made the rest of us look like children with calculators. Within 10 days, she traced over $20,000 in HOA expenses to a shell company registered under Sheila's maiden name. "She was laundering HOA dues," Marjorie said flatly, pointing to a stack of bank records. "This wasn't just abuse of power, this was theft." The committee presented our findings to the district attorney's office. Additional charges were filed: embezzlement, wire fraud, and tax evasion. The judge overseeing the case approved a motion to freeze Sheila's assets until the trial. Meanwhile, the neighborhood transformed. The new board held open meetings in the community park under the shade of a big oak tree. Residents brought lawn chairs and coolers. Children ran around playing tag while adults discussed landscaping plans and budget allocations. For the first time in years, people actually wanted to participate. One afternoon, Glenn approached me with a grin, not smug, just satisfied. "You ever think about running for the board?" he asked. "Not unless I get a cape and a gavel," I said. He laughed. "Well, you've got the cape part down. Everyone's calling you the guy who cracked the code." "I just know how to read a deed. Most people don't." "You saw through the whole thing when the rest of us were too tired to care." A month later, the neighborhood voted to dissolve the old HOA charter entirely. They replaced it with a new, simplified system managed by a resident council, no president, no secret meetings, just elected liaisons with term limits and public transparency. The bylaws were stripped down to basic maintenance standards and a shared emergency fund. The garden I'd started on the reclaimed side lot bloomed with wildflowers that summer. Someone added a little wooden plaque that read, "This land was reclaimed with facts, not fear." As for Sheila, her trial was set for the fall. The last I heard, her defense attorney was arguing she was misled by outdated records. But with the chain of emails, the false permits, and the financial trail, the case was solid. The neighborhood was no longer afraid of its own leadership. People spoke up, asked questions, and reviewed documents before signing anything. The mood had shifted from quiet compliance to cautious empowerment, and me. I went back to my usual routine: coffee in the morning, tending the garden, and helping neighbors when they asked. Not because I wanted recognition, but because it felt good to live somewhere that finally belonged to the people who actually lived there. The criminal trial against Sheila Warden and her husband opened on a brisk Monday morning in early October. I didn't attend out of spite. I attended because the courtroom was public, and I had a vested interest. Not just in the outcome, but in seeing accountability finally catch up to someone who had spent years weaponizing bureaucracy against her neighbors. The courtroom was smaller than it looked on TV. No dramatic lighting, no echoing gavels, just worn benches, a tired judge, and a crowd of attentive faces, most of them from our neighborhood. Glenn sat on my left, his arms folded tight, while Dolores sat on my right, tapping a pen against her notepad. The prosecution laid everything out with surgical precision, led by an assistant district attorney named Reena Patel. She didn't waste time on theatrics. Instead, she guided the jury through a timeline of deceit: falsified permits, embezzled HOA funds, fabricated amendments, and the unauthorized sale attempts of parcels the HOA never owned. Her key evidence was a 3-page ledger found in a locked filing cabinet in Sheila's garage, discovered during a warranted search. It contained handwritten entries listing reimbursement payments made to herself and her husband, tagged with vague descriptions like community beautification and compliance bonuses. The amounts ranged from small under $50 to several thousand. The total came to nearly $35,000. The defense tried to argue that Sheila had simply been overwhelmed with responsibility and had made clerical errors. They cast her not as a schemer, but as a volunteer caught in a tangle of outdated records and poor communication. Her attorney, a man with too much cologne and a habit of adjusting his tie before every sentence, insisted she had acted in good faith. Then Patel introduced Exhibit G, a voice recording. It had been captured by a former board member, one who'd quietly resigned 3 years earlier after growing suspicious of Sheila's conduct. In the recording, Sheila can be heard telling her husband, "If no one checks the filings, we can just say it was approved last year. They'll never notice. We've been doing it that way forever." The courtroom fell quiet. The defense didn't recover after that. By the end of the week, Sheila was convicted on 6 counts of fraud, 2 counts of filing false instruments, and 1 count of conspiracy to commit property theft. Her husband was found guilty of aiding and abetting, along with forging multiple permit signatures. The judge ordered Sheila to repay the embezzled funds in full, plus restitution to every homeowner who'd been fined under fabricated violations. He handed down an 18-month prison sentence, with eligibility for parole after 1 year. Her husband received a reduced sentence, 9 months in county jail, after agreeing to testify against her during the pre-trial phase. Their assets, including her home, were frozen pending civil claims. Dolores' lawsuit settled quietly a few weeks later. She didn't discuss the amount, but judging by the smile she wore the next time we bumped into each other near the garden, it had been worth it. With the legal dust settling, the neighborhood turned its attention to rebuilding not just its policies, but its sense of trust. The new resident council, now fully elected and rotating every 12 months, implemented a system of radical transparency. All decisions were posted publicly, budgets were reviewed quarterly in open forums, and any proposed changes to shared spaces required a 2/3 resident vote. There were no more secret amendments or obscure fines. Everyone got a say, and every voice counted. One of the first items passed was a formal land use resolution, permanently protecting the garden I'd started from any future development or annexation. It was reclassified as a community trust space, with its own tax ID and a small fund supported by optional contributions. I didn't ask for it, but I appreciated the gesture. One Saturday, while I was pruning the rosemary bush near the fence line, a woman I hadn't met before approached me. She was carrying a paper bag from the bakery down the street and looked like she'd just moved in. "You're Fletcher, right?" she asked, setting the bag down on the bench. "I'm Naomi. Just bought the blue house at the end of the cul-de-sac," I nodded. "Welcome to the most dramatic suburban development this side of the Mississippi," she laughed. "I heard rumors. Something about a rogue HOA president and stolen land. Something like that. But we're in the recovery phase now. You picked a good time to move in." Naomi pulled a lemon scone from the bag and handed it to me. "I figured the guy who built the garden should get the first welcome gift." I accepted it and gestured to the bench. "Stick around. You'll find out this place is a lot better when it's run by its people, not its paperwork." Over the next few months, things continued to improve. With Sheila gone and the old board dissolved, long-stalled projects finally moved forward. Sidewalks were repaired. A new community bulletin board was installed near the mailbox cluster. Someone organized a fall cleanup day, and more than 30 people showed up with rakes, leaf bags, and slow cookers full of chili. The most symbolic moment came just before winter, when a group of kids from the neighborhood painted a mural on the side of the old HOA storage shed. It depicted a long vine stretching across a row of houses, weaving through gardens and porches, linking everyone together. In small lettering above it, they painted, "We grow stronger together." It wasn't just art, it was a declaration. And for me, it meant that all the late nights digging through records, all the quiet hours spent collecting evidence, and every bit of legal frustration had been worth it. I never wanted to be the face of a neighborhood battle. But when someone tries to rewrite the rules to suit their own power, you either roll over or you stand up. I stood up, and this time the system stood with me. The garden stayed open year-round. People brought folding chairs in the spring and held coffee chats on Saturday mornings. Kids ran through the narrow paths, chasing butterflies between the wildflowers. Someone started a compost bin. Someone else added a chalkboard for recipe swaps. It became more than a garden, it became proof that a neighborhood could reclaim itself. Sheila's old house sold quietly, without fanfare. The new owners never mentioned her name, and no one brought it up. The past had its place, but we had moved on. As for me, I went back to my law practice downtown, though I worked fewer hours now. I'd earned some breathing room. Sometimes Naomi would stop by the garden with a fresh loaf of bread, and we'd sit and talk about things that had nothing to do with property lines. No more lawsuits. No more schemes. Just a neighborhood that had learned the hard way what happens when power is left unchecked and how strong people can be when they finally say, "Enough."